Before we begin, a quick and important disclaimer. The following presentation is designed and intended strictly for educational, academic, and entertainment purposes only. The intersection of American civil family law and Islamic jurisprudence is a highly complex, deeply nuanced, and constantly evolving legal landscape. Nothing in this video or this entire masterclass series constitutes legal representation, financial guidance, religious decrees, or professional counseling of any kind. Family law in the United States is primarily governed at the state level, meaning that the legal procedures, precedents, and potential outcomes regarding asset division, child custody, and contract enforcement can and will vary drastically depending on whether you reside in New York, California, Texas, or any other jurisdiction. Furthermore, the application of Islamic law or Sharia regarding marriage and divorce is subject to multiple schools of thought, cultural interpretations, and the specific rulings of local religious scholars or arbitration tribunals. Because the United States Constitution, specifically through the Establishment Clause of the First Amendment, prohibits civil courts from entangling themselves in religious doctrine, the way a secular judge interprets a religious marital contract is highly unpredictable. Therefore, it is absolutely critical that any individual navigating a divorce process consults directly with the licensed, specialized family law attorney in their specific state, as well as a qualified, recognized religious scholar to understand their unique rights and obligations under both systems. You must conduct your own due diligence, heavily research your local statutes, and build a team of vetted professionals to handle your specific circumstances. We are here to explore the sociological data, historical trends, and academic case studies, not to provide a roadmap for your personal legal or spiritual life. Imagine standing in a beautifully appointed courtroom in the United States, holding a court-stamped legal decree signed by a civil judge. This piece of paper definitively declares that your marriage is over, your assets have been equitably distributed, and you are entirely free, in the eyes of the state and the federal government, to walk away and rebuild your life. You are, by every metric of American law, a divorced individual. But when you return to your community, to your family, and to your faith, you are told that you are still completely and legally bound to your spouse. You are trapped in what sociologists and legal scholars refer to as a limping marriage. This is not a rare anomaly or a bizarre exception. This is a deeply distressing and increasingly common reality for thousands of American Muslims today. A limping marriage occurs when an individual successfully obtains a civil divorce through the American secular court system, but cannot secure the religious divorce, known in Islamic tradition as Talaq or Khula, effectively paralyzing them in a state of legal pluralism. In the eyes of the state, they are single. In the eyes of their faith community, they are married, meaning they cannot religiously remarry or move forward without facing severe social and spiritual ostracization. Consider the staggering friction point that occurs when a 1400-year-old tradition of religious jurisprudence collides head-on with the modern American legal system. The stakes are incredibly high, and the confusion is pervasive. Let us examine the mahr, the mandatory Islamic marital gift or dowry. To a Muslim couple, the mahr is a sacred religious obligation and a fundamental pillar of the marriage contract, often promising a specific sum of money or assets to the wife in the event of a divorce. But when that couple enters an American courtroom, how does the judge view this document? Through various case studies over the last 3 decades, we have seen completely fractured legal outcomes across the country. In some states, a judge might view the mahr as a standard prenuptial agreement, enforceable under basic contract law as long as it was signed without duress. In other states, a judge might look at the very same document, see the religious terminology, and immediately dismiss it, citing the First Amendment and stating that an American court cannot enforce a religious contract. This creates a volatile environment where an individual's financial security and future stability are entirely dependent on the geographical lottery of where they file their paperwork and the personal legal philosophy of the judge sitting on the bench that day. We are witnessing a fascinating and often painful sociological shift. Historical trends show that as the Muslim American population grows, matures, and integrates, their divorce rates are steadily climbing to mirror the national averages of the broader United States population. Yet, the infrastructure to handle these specific cultural and religious nuances is desperately lagging behind. The emotional toll, financial devastation, and the community fragmentation that results from this legal blind spot are profound. We are talking about individuals who have to fight 2 simultaneous battles. One in a secular courthouse with lawyers, mediators, and discovery processes, and another in community centers or private living rooms with religious leaders, families, and community tribunals, often receiving conflicting advice and contradictory mandates from both sides. This masterclass is the definitive academic review of how divorce actually functions for Muslims living in the United States today. We are going to completely deconstruct the dual legal reality that Muslim Americans must navigate, providing you with a rigorous step-by-step understanding of the structural challenges and the historical legal precedents that define this space. For the American Muslim audience, this series will solve the critical problem of systemic confusion and institutional isolation. You will gain a profound understanding of how your religious contracts interact with state laws, empowering you with the vocabulary and the academic framework needed to understand your civil and spiritual landscape. For legal professionals, sociologists, community leaders, and the intellectually curious general public, this is an unparalleled deep dive into one of the most fascinating intersections of constitutional law, minority rights, and religious freedom in modern America. Throughout this comprehensive series, we will bypass the surface-level talking points and dive straight into the empirical data, the peer-reviewed sociological studies, and the landmark court decisions. We will meticulously break down the mechanics of Talaq and Khula, and how they are aggressively misunderstood by the Western legal apparatus. We will explore the rise of alternative dispute resolution and independent religious arbitration panels in states like Texas and Virginia, examining how these parallel systems attempt to mediate outcomes outside of the traditional courtroom while staying within the boundaries of state law. We will look at extensive case studies regarding child custody battles where cultural norms regarding gender roles and religious upbringing are put on trial before secular judges. We will also dissect the generational divide, looking closely at historical trends to understand how the children of immigrants, second and third generation Muslim Americans, are radically redefining the concepts of marital counseling, mental health, and the stigma of divorce within their own communities. You are going to learn how different jurisdictions interpret the First Amendment when it comes to religious family law, why some community leaders are pioneering standardized, legally enforceable Islamic marriage contracts that pass secular muster, and what the potential outcomes look like when a community attempts to bridge the gap between religious fidelity and civil compliance. This is not just a study of the law. It is a profound examination of identity, constitutional limits, and the human experience within a pluralistic society. By the end of this journey, you will possess a master-level comprehension of the most critical, high-stakes issues surrounding Islamic divorce in the United States, armed with the academic clarity to understand exactly how we got here, and where the legal and sociological trends are aggressively heading next. To understand the sheer gravity of this legal intersection, we must first look at the foundational document of an Islamic marriage, the nikah, and specifically the financial provisions embedded within it. When a Muslim couple marries, they sign a contract that includes a mandatory financial gift from the husband to the wife, known as the mahr. This is absolutely not a bride price, nor is it a traditional dowry where the bride's family pays the groom. From an academic and legal standpoint, the mahr is a unilateral contractual obligation intended to provide the wife with independent financial security. Historically, and increasingly in the modern American context, this gift is divided into two distinct parts. The prompt portion is given at the time of the marriage ceremony, while the deferred portion is explicitly payable upon either the death of the husband or the dissolution of the marriage through divorce. In the year 2026, as inflation, housing costs, and broader economic pressures mount across the United States, this deferred financial provision is no longer just a symbolic gesture. It often represents a substantial, critical financial safety net, sometimes amounting to tens of thousands of dollars or specific high-value assets. Imagine if you are a woman named Sarah living in suburban Illinois, right now in 2026. You married your husband Michael 10 years ago, and together you signed a standard Islamic marriage contract at your local community center. The agreed-upon deferred provision was $50,000. Over the past decade, you both built a life, acquired a mortgage, and contributed to retirement accounts. However, the marriage ultimately breaks down, and you find yourself filing for a civil divorce in an American family court. You hand your civil attorney your signed religious contract, expecting that the $50,000 promised to you will be swiftly enforced by the judge alongside the division of your house and cars. This is where the theoretical framework violently collides with the harsh reality of American jurisprudence. When your case sits before a secular judge in the United States, that judge is strictly bound by the United States Constitution, specifically the Establishment Clause of the First Amendment, which completely bars the government from entangling itself in religious affairs or interpreting religious doctrine. To navigate this, American courts utilize a legal framework known as the neutral principles of law doctrine. This means that a secular judge will only look at your religious marriage contract through the exact same lens they would use to look at a secular commercial business contract. They look at the four corners of the document. If your contract simply states that Michael owes Sarah $50,000 upon the event of divorce, a judge in many states might view this as a straightforward, enforceable prenuptial agreement. However, historical trends and extensive case studies reveal a massive systemic failure point right here. Most religious marriage contracts are not drafted by secular lawyers. They are drafted by religious leaders and are steeped in theological language. If your contract states that the $50,000 is to be paid according to Islamic law, or if it references the Quran and the Sunnah as the governing authority over the contract, the secular judge will almost certainly refuse to enforce it. The judge will declare that they cannot legally determine what Islamic law dictates without violating the separation of church and state. In an instant, purely due to the phrasing of a document signed 10 years prior, your $50,000 safety net evaporates in the civil courtroom. Your attorney, likely untrained in the nuances of Islamic jurisprudence, is entirely unequipped to salvage the agreement. But the loss of the financial provision is only the first layer of the crisis. We must now examine the actual mechanics of the religious divorce itself. In Islamic tradition, a husband possesses the unilateral right to pronounce divorce, known as Talaq. If Michael decides he wants the divorce, the religious process is generally straightforward. However, if Sarah is the one initiating the divorce because of irreconcilable differences, emotional distance, or other non-violent factors, she must seek a Khula. A Khula is a religiously sanctioned divorce initiated by the wife, but crucially, it historically requires the wife to return her mahr, or give up her financial rights, in exchange for her husband releasing her from the marital bond. Now, superimpose this religious framework over the civil legal system of an equitable distribution state like Illinois or a community property state like California. In the civil court, the judge looks at the marital assets, the house, the bank accounts, the retirement funds, and divides them according to state law, often resulting in a roughly 50-50 split. Sarah is legally awarded her half of the civil assets. The civil divorce is finalized. She is a free woman under American law. But Michael is angry about the civil asset division. When Sarah goes to the local religious tribunal or community leaders to finalize her religious divorce, so she can move on with her spiritual life, Michael utilizes the religious system as a weapon. He refuses to grant the religious release unless Sarah agrees to return the assets she just won in the civil court. This creates an environment of devastating religious extortion. We are seeing a documented rise in potential outcomes where women are civilly divorced but religiously held hostage. The husband essentially tells the wife that if she wants to be recognized as a single woman in their community, if she ever wants to be able to marry again within her faith, she must sign over the civilly awarded house or empty her civilly awarded retirement account to buy her religious freedom. This extortion dynamic places immense psychological and financial pressure on the individual. The community leaders mediating these disputes are often caught in an impossible position. Some religious leaders demand that the couple finalize their civil divorce before they will even hear the religious case. But civil divorces in the United States can easily take 2 to 3 years of agonizing discovery processes, mandated separation periods, and endless court dates. During this massive temporal gap, the individual is paralyzed. They are stuck in a limping marriage, draining their financial resources to pay civil attorneys while simultaneously facing extreme social ostracization from a community that views them as still married. The step-by-step reality of this process is grueling. First, the civil filing occurs, triggering a mandatory waiting period. Second, the financial affidavits are exchanged, often ignoring the religious contract entirely because civil lawyers do not know how to classify it. Third, the mediation phase fails because the husband holds the religious divorce as leverage. Fourth, the civil trial concludes, dividing the assets based on state law. Fifth, the battle shifts entirely to the religious arena, where the civil ruling is completely ignored by the husband, and the wife is forced to essentially litigate her divorce a second time, this time without the protection of secular state law. This dual legal burden is entirely unsustainable, and it is fracturing families across the country. It forces us to ask a critical question about the limits of the American legal system. If the secular courts cannot protect these individuals due to the First Amendment, and the traditional religious tribunals are being weaponized by bad actors, where does an American Muslim turn to find equitable justice? The resulting vacuum has led to one of the most controversial and rapidly expanding sociological developments in the United States legal landscape today. Desperate for a solution, communities are abandoning the traditional local mosque mediators and are instead signing binding contracts with highly organized, legally sophisticated independent religious arbitration panels. But what happens when these private, closed-door arbitration panels, operating entirely outside the oversight of a secular judge, make decisions that fundamentally violate an individual's constitutional rights? To answer that question, we have to examine a piece of federal legislation passed over a century ago that is radically reshaping American family law today. The Federal Arbitration Act, originally enacted in 1925, was primarily designed to allow commercial merchants to resolve interstate shipping and business disputes out of court without burdening the public legal system. Today, in the year 2026, this exact same corporate legal framework serves as the powerful statutory backbone allowing private, religious tribunals to issue legally binding rulings on Islamic divorce, property division, and spousal support across the United States. The law establishes a staggering and rigid precedent. If two consenting adults sign a written contract agreeing to resolve their future disputes through private arbitration, the secular American court system will vigorously enforce that agreement. A state judge will actively compel the parties out of the public courtroom and legally force them into the private tribunal. Furthermore, once the arbitration is complete, the secular courts will enforce the final decision of that religious arbitrator with the exact same weight, authority, and police power as a judgment handed down by a sitting state judge. Imagine if you are a woman named Emily living in Austin, Texas in 2026. You are preparing to marry your fiancé Omar, and amid the joy, stress, and chaos of wedding planning, you are presented with a standardized Islamic marriage contract by the local religious officiant. Buried within the dense theological language and the mandatory MAR provisions is a single, heavily legalized paragraph outlining that any future disputes regarding this marriage, including dissolution, will be exclusively settled by a specific regional Islamic arbitration council. Believing this is simply a standard cultural formality required to legitimize the marriage in the eyes of your community, you sign the document without consulting independent civil legal counsel. Fast forward 8 years, the marriage critically fails, and you hire a civil family law attorney to file for divorce in the Texas state court system, seeking a standard equitable division of the assets you and Omar have painstakingly accumulated during your marriage. This is precisely where the legal trap aggressively closes. Omar retains his own counsel, who immediately files a motion to compel arbitration, presenting your signed religious contract to the secular judge. Historical trends and extensive legal case studies demonstrate that the secular judge will almost always grant this motion. The civil judge will officially stay the civil proceedings, effectively pausing your secular divorce, and legally force you to submit to the jurisdiction of the religious arbitration panel. In the blink of an eye, you have just been legally exiled from the constitutional protections, the rigorous evidence rules, and the equitable distribution statutes of the Texas family court system. Once you are forced inside the closed doors of the religious arbitration panel, the rules of the game change entirely, often to the severe detriment of the financially vulnerable spouse. The arbitrators, who are typically religious scholars or community leaders rather than state-licensed attorneys, are not bound by the civil family code of your state. They are guided entirely by their specific interpretation of Islamic jurisprudence. In civil court, you have the absolute power of the state to issue subpoenas for bank records, force depositions under oath, and compel the production of hidden cryptocurrency wallets or offshore accounts. In private religious arbitration, the arbitrator's power to force a hostile spouse to turn over hidden financial documents is often severely limited or completely non-existent. If Omar is hiding assets, Emily has virtually no procedural mechanism to force him to reveal them. Furthermore, the panel might look at the marital assets, which include a rapidly appreciating house and robust joint retirement accounts, and decide that under their specific interpretation of traditional Islamic law, the concept of joint marital property does not exist. They might issue a ruling stating that Emily is only entitled to the deferred MAR listed in her contract, perhaps $10,000, while Omar retains the entirety of the $400,000 marital estate, simply because his name is listed on the primary property deeds and brokerage accounts. When the arbitration panel issues this final, devastating ruling, Emily is left financially ruined. Her immediate and natural response is to rush back to the secular judge to appeal this disastrous outcome, arguing that it is fundamentally unfair, wildly disproportionate, and violates her basic civil rights. But the academic reality of American arbitration law is terrifyingly strict. Under the Federal Arbitration Act and parallel state arbitration laws, a secular judge cannot overturn an arbitration award simply because it is unfair, or because the arbitrator made a massive mistake of law, or because the financial outcome is vastly different from what the state court would have ordered. The legal standard to vacate an arbitration award requires proving extreme, almost impossible circumstances, such as outright fraud, blatant corruption, or proving that the arbitrator explicitly exceeded their granted contractual authority. Proving these elements is incredibly difficult, astronomically expensive, and statistically rare. In the vast majority of cases, the secular judge will simply rubber stamp the religious tribunal's decision, making Emily's financial ruin a permanent, legally binding reality with zero public record or court transcript for future appeal. This dynamic creates an incredibly dangerous asymmetry that is heavily favored by the state. The secular legal system actively encourages and protects alternative dispute resolution, because family courts across the United States in 2026 are catastrophically backlogged and underfunded. Judges are desperate to clear their dockets, so they heavily favor the enforcement of arbitration clauses. However, for vulnerable spouses who unknowingly signed away their litigation rights on their wedding day, this judicial efficiency comes at the total cost of their constitutional protections. We see exact parallel legal structures existing within Orthodox Jewish communities utilizing the Beth Din courts, and various Christian denominations using Christian peacemaker tribunals. The fundamental societal tension remains identical across all these groups. When religious freedom allows individuals to legally opt out of the secular justice system, who protects the party that is systematically disadvantaged by the patriarchal rules of the religious system they opted into? There is, however, one massive structural exception to the absolute power of religious arbitration panels, and it revolves around the most contentious aspect of any modern divorce. While an arbitration panel can absolutely bind the parties regarding property division, spousal support, and debt allocation, they possess absolutely zero binding authority over the custody and financial support of minor children. In the United States, the state operates under the deeply entrenched legal doctrine of parens patriae, meaning the state acts as the ultimate protector and parent of all children within its borders. Any legal decision regarding children must be made strictly under the secular legal standard of the best interests of the child. Therefore, if a religious arbitration panel rules that a father automatically receives full custody based on a traditional cultural interpretation of gender roles, or mandates a monthly child support amount that falls below the state-calculated minimum guidelines, a secular judge will immediately intervene and strike that specific portion of the arbitration award down. This jurisdictional split creates a deeply fractured, highly inefficient, and incredibly expensive legal reality for Muslim Americans going through a contentious divorce. They are forced into a brutal bifurcated process. They must litigate their money, houses, and retirement accounts in front of a private religious panel, while simultaneously fighting a bitter, separate battle over the custody of their children in the public secular courthouse. They are paying two entirely separate sets of legal fees, navigating two conflicting sets of procedural rules, and dealing with two entirely different philosophical approaches to family dynamics. The psychological toll of fighting this two-front war is devastating, and it forces civil family law attorneys to adopt unprecedented litigation strategies to protect their clients from being crushed by the dual systems. But what happens when the very foundation of this entire process is aggressively challenged from the start? What occurs when an individual returns to the secular court and argues that the binding arbitration clause they signed on their wedding day is entirely invalid and should be thrown out? We must look at the explosive case studies emerging right now, where the validity of the religious contract itself is attacked on the grounds of extreme coercion, duress, or the terrifying presence of domestic violence. How do secular courts respond when a victim of severe abuse claims that forcing them into a closed-door, unrecorded religious mediation with their abuser is not an exercise of religious freedom, but a state-sanctioned facilitation of continued trauma and control? This is the exact intersection where the theoretical protection of religious freedom violently clashes with the state's paramount duty to protect its citizens from physical and psychological harm. When an individual attempts to invalidate a religious arbitration agreement, they cannot simply walk into an American courtroom and argue that the underlying religious law is inherently unfair or patriarchal. Because of the First Amendment, an American judge cannot and will not evaluate the fairness or the theological validity of Islamic jurisprudence. Instead, the civil attorney must aggressively pivot the entire case away from religion and directly into the realm of secular contract law, specifically utilizing the rigorous legal doctrines of duress, fraud, or unconscionability. They must prove that the contract itself is fundamentally flawed based purely on how it was signed. Imagine if you are a woman named Fatima living in Dearborn, Michigan, in the current year 2026. You are desperately seeking a civil divorce from your husband, Talaq, after enduring years of documented domestic violence, severe emotional abuse, and intense financial control. The moment your civil attorney files the initial divorce petition, Talaq's legal team immediately counters by filing a formal motion to compel arbitration, presenting the secular judge with the NICA contract you signed 15 years ago. This document contains a legally binding clause mandating that all marital disputes must be resolved by a specific private religious council. Your attorney must now convince a secular judge that your signature on that document, executed a decade and a half ago, was not a product of your own free will, and therefore, the state cannot force you into a closed room with your abuser. This presents a monumental evidentiary hurdle. Fatima cannot simply testify that she felt culturally pressured to sign the document. The secular court requires empirical, overwhelming evidence of legal duress at the exact moment of the contract formation. Religious marriage contracts are typically signed in front of families, community elders, and religious figures in highly celebratory, yet intensely pressurized social environments. If Fatima argues that she only signed the arbitration clause because her family would have socially ostracized her if she refused, historical trends in American contract law overwhelmingly demonstrate that courts rarely, if ever, classify family disappointment or social pressure as legal duress. Under secular legal standards, duress typically requires the explicit threat of imminent physical harm or severe, unlawful action. However, if Fatima can produce a timeline of police reports, hospital records, or extensive psychological evaluations demonstrating a pervasive, terrifying pattern of coercive control that obliterated her ability to consent freely on her wedding day, the secular court faces a massive constitutional dilemma. To force a documented victim of severe abuse into an unrecorded, private mediation room with their abuser fundamentally undermines the entire conceptual foundation of alternative dispute resolution. Arbitration relies entirely on the premise of two equal parties negotiating in good faith to reach a mutual agreement. When extreme domestic violence is present, there is no equality. There is only a predator and a victim. This shifts the battleground directly into the civil courtroom for a highly specialized, grueling procedural fight known as an evidentiary hearing. It becomes an absolute legal war before the actual divorce even begins. Talaq's lawyers will fiercely argue First Amendment rights, claiming that any state interference with the religious arbitration panel is a gross infringement on their constitutional right to the free exercise of religion. Fatima's lawyers will counter with the doctrine of public policy exceptions. They will argue that while the state respects religious freedom, state law absolutely and fundamentally forbids the enforcement of any private contract that facilitates abuse, endangers a citizen, or strips away fundamental human rights. The secular judge must meticulously dissect the circumstances surrounding the signing of the contract, analyzing everything from the presence of independent legal counsel to the exact phrasing of the Arabic terminology, all without ever looking at or judging the religious content of the contract itself. This exposes a terrifying systemic vulnerability regarding how private tribunals operate in the United States. Religious arbitration panels are completely private entities. They are not state-mandated reporters of domestic violence in the same way that public school teachers, therapists, or medical professionals are legally required to be in many jurisdictions. If severe physical abuse is disclosed behind the closed doors of a religious tribunal during a divorce mediation, there is absolutely no statutory guarantee that local law enforcement will be notified, that protective restraining orders will be issued, or that the victim will be shielded from retaliation. The primary focus of many traditional religious tribunals is heavily weighted toward family preservation and spiritual reconciliation, rather than secular punitive justice or strict victim protection. This philosophical divergence can lead to disastrous potential outcomes for the vulnerable spouse, who may be pressured by religious figures to remain in a dangerous environment for the sake of the community or the children. Furthermore, secular courts are increasingly grappling with the doctrine of unconscionability, which is divided into procedural unconscionability, meaning the process of signing was unfair, and substantive unconscionability, meaning the actual terms of the contract are so overwhelmingly one-sided that they shock the conscience of the court. If an arbitration panel routinely awards the entirety of a massive marital estate to the husband while leaving the wife destitute, a secular appellate court might eventually intervene, ruling that the arbitration agreement itself is unconscionable and therefore void. But reaching that appellate level requires years of litigation and staggering financial resources. Fatima might easily spend $50,000 to $80,000 just fighting the preliminary battle of jurisdiction, trying to prove she belongs in a civil court, before a single asset is divided or a child custody schedule is even discussed. This brutal financial attrition tactic is frequently weaponized by the wealthier spouse to force the vulnerable spouse into a highly unfavorable out-of-court settlement, simply because they run out of money to continue fighting the jurisdictional war. This brings us to a critical paradigm-shifting realization in the year 2026. If the traditional overseas imported Islamic marriage contracts are consistently failing Muslim Americans in secular courts, and if private religious arbitration panels are fraught with constitutional landmines and potential human rights abuses, how is the community actively adapting to survive? The answer lies in a radical, rapidly accelerating grassroots legal movement that is fundamentally transforming the landscape right now across the country. A new generation of highly specialized American Muslim family law attorneys, working in tandem with progressive, academically rigorous religious scholars, are completely tearing up the old templates. They are meticulously redesigning the Islamic marriage contract from the ground up, utilizing highly aggressive, sophisticated secular corporate legal strategies to legally bind religious obligations within the ironclad, inescapable confines of American civil law. But when you attempt to fuse 1400 years of sacred, unalterable theological tradition with modern American contract drafting, what kind of unprecedented legal anomalies are created? And why are some traditionalist communities fighting so desperately to stop this modernization from happening? To understand this radical transformation, we must analyze exactly how these progressive legal minds are essentially hacking the American judicial system to protect vulnerable spouses. They are achieving this by completely weaponizing the neutral principles of law doctrine that previously destroyed so many traditional religious contracts. If a secular judge is legally mandated to look at a religious marriage contract as if it were a standard corporate agreement, the new strategy is to simply give the judge exactly what they are looking for: a highly sophisticated, secularly drafted corporate prenuptial agreement that mathematically achieves the exact same financial and protective outcomes as the religious doctrines require, but without ever using a single religious word that could trigger the First Amendment. Imagine if you are a woman named Zara living in New Jersey in the current year 2026. You are preparing to marry Daniel, and instead of simply downloading a generic, one-page Islamic marriage certificate from the internet, your family retains a highly specialized, dual-licensed attorney who understands both New Jersey family law and Islamic jurisprudence. This attorney drafts a comprehensive, 40-page prenuptial agreement. When it comes to the mahr, the deferred financial gift of $100,000, the word mahr is completely erased from the English translation of the document. Instead, the contract utilizes standard American financial terminology. It outlines a legally binding promissory note and a liquidated damages clause, explicitly stating that upon the filing of a civil dissolution of marriage by either party, Daniel is contractually obligated to pay Zara a lump sum of $100,000, entirely independent of the state-mandated equitable distribution of their shared marital assets. Furthermore, this modernized contract aggressively tackles the most dangerous friction point we discussed earlier: the weaponization of the religious divorce. In traditional Islamic law, there is a mechanism known as Talaq al-Tafwid, which is the delegated right of divorce. This allows the husband to delegate his unilateral power to dissolve the marriage directly to the wife at the time the contract is signed. The specialized American attorney takes this ancient theological concept and translates it into an ironclad secular legal mechanism. The 2026 prenuptial agreement includes a specific, legally enforceable clause granting Zara an irrevocable power of attorney specifically limited to the execution of religious divorce documents. This means that if Daniel attempts to hold the religious divorce hostage to extort Zara for her civil assets, Zara literally holds the legal authority to sign the religious divorce paperwork on his behalf. When this highly engineered contract eventually lands on the desk of a secular family court judge in New Jersey, the judge does not see a confusing theological puzzle that requires a First Amendment dismissal. The judge sees a perfectly formatted, legally sound civil prenuptial agreement complete with financial disclosures, independent counsel sign-offs, and standard severability clauses. The judge enforces the $100,000 payment not because it is a sacred religious obligation, but because it is a valid civil contract. Zara is protected, her financial safety net is secured, and her spiritual freedom is guaranteed entirely through the utilization of secular corporate legal strategies. However, this aggressive modernization has birthed a series of unprecedented, highly controversial legal anomalies that are currently causing massive debates within academic and constitutional circles. By stripping the religious language from these contracts and forcing them into secular legal templates, lawyers are inadvertently inviting secular judges to enforce religious behavioral compliance. We are seeing the rise of lifestyle clauses within these modernized agreements. In a standard celebrity prenuptial agreement, you might see a clause stating that if a spouse commits adultery, they forfeit a certain percentage of the marital estate. Specialized attorneys are now adapting these lifestyle clauses to mirror religious expectations. Consider a scenario where a modernized contract includes a clause stating that the deferred financial payment increases by $10,000 if the husband is proven to have consumed alcohol or engaged in gambling, activities strictly prohibited in Islamic tradition. To bypass the First Amendment, the contract defines these actions purely as detrimental lifestyle choices that negatively impact the marital estate. When the marriage fails, the secular judge is now placed in the bizarre position of conducting civil discovery to determine if the husband drank alcohol, and then enforcing a financial penalty based on that behavior. The state, completely by accident and through the clever manipulation of secular contract law, is now effectively acting as a proxy enforcer of Islamic moral codes. This exact phenomenon is why some traditionalist communities and orthodox religious scholars are fighting so desperately to stop this modernization from happening. From their perspective, the nikah is not a corporate merger. It is a sacred covenant fundamentally rooted in divine law. By intentionally erasing the name of God, stripping away the theological terminology, and contorting sacred obligations to fit into the rigid, secular boxes of American commercial contract law, traditionalists argue that the very soul of the marriage is being destroyed. They view this legal hacking as a dangerous form of secular assimilation that compromises the integrity of the faith. They argue that Amar enforced purely as a secular promissory note ceases to be Amar at all, becoming nothing more than a sterile financial transaction devoid of its intended spiritual weight and blessing. Furthermore, traditionalists raise a profound institutional concern. If the American Muslim community begins to rely entirely on secular civil courts to enforce their religious marriage contracts through these legal loopholes, they will completely abandon the internal development of their own community institutions. Why would a community invest millions of dollars and decades of effort into building legally sound, highly trained, and deeply ethical religious arbitration panels if everyone simply uses specialized civil prenups instead? The fear is that this reliance on the secular state will cause the communal infrastructure to wither and die, leaving future generations entirely dependent on a secular legal system that fundamentally does not understand their faith, their culture, or their values. This creates a massive ideological civil war within the American Muslim legal community in 2026. On one side, the progressive lawyers argue that protecting women from financial ruin, domestic abuse, and religious extortion in the immediate present is paramount, and secular legal hacking is the only effective tool available. On the other side, traditionalists argue that the long-term survival of their religious identity requires building parallel institutions that operate with theological integrity, even if those systems are currently imperfect and struggling to adapt to the American landscape. But while this elite legal and theological debate rages in academic journals and high-end law firms, a much darker, far more dangerous sociological crisis is exploding quietly in the shadows of these communities. What happens when individuals decide to completely bypass the secular legal system altogether? What occurs when the very definition of marriage is challenged by practices that are culturally recognized but strictly, criminally illegal under United States federal and state law? We must now turn our attention to the devastating, hidden world of unregistered religious marriages, and specifically examine how the clandestine practice of polygamy is completely destroying the financial futures and civil rights of women who believe they were entering into a protected union, only to discover they are legally invisible to the state. To comprehend the sheer magnitude of this hidden crisis, we must first completely separate the theological concept of marriage from the secular, administrative reality of the American state. In the United States, a marriage is fundamentally a civil contract authorized by a state government through the issuance of a marriage license. Religious officiants such as imams, priests, or rabbis act as dual agents. They perform the spiritual ceremony for the community, but they also act as temporary agents of the state by signing that civil license and filing it with the county clerk. However, a massive and deeply destructive loophole exists. If a couple undergoes a massive, culturally elaborate Islamic marriage ceremony, complete with a nikah contract, hundreds of guests, and total communal recognition, but they intentionally or negligently fail to file a civil marriage license with the state, They are completely invisible to the American legal system. They exist in a terrifying legal vacuum. Imagine if you are a woman named Yasmin living in Columbus, Ohio, right now in the year 2026. You are introduced to Dr. Hassan, a highly respected, affluent member of the local community. After a brief courtship, he proposes. He insists on having a beautiful religious nikah ceremony immediately to ensure your relationship is spiritually pure and culturally validated before God and your families. However, he tells you that for complicated tax purposes, asset protection regarding his medical practice, or perhaps a pending real estate transaction, you should wait a year or two before filing the actual civil paperwork at the courthouse. Trusting his status and surrounded by the overwhelming social proof of a massive wedding banquet, you agree. You move into his sprawling home. Over the next 6 years, you sacrifice your own career to raise 3 children, manage the household, and support his professional ascent. In the eyes of your community, your family, and your faith, you are unequivocally a devoted wife. Then the relationship catastrophically collapses. You discover a pattern of profound financial abuse and infidelity. Desperate to protect yourself and your children, you hire a civil family law attorney to file for a standard divorce, seeking child support, alimony, and your equitable share of the massive marital estate you helped build over the last 6 years. The attorney takes your retainer, files the petition in the Ohio Family Court, and awaits the response. The legal retaliation from Hassan is swift, brutal, and entirely legal. His corporate attorneys do not argue about asset division or alimony. They file a devastating motion to dismiss your entire case based on an absolute lack of legal standing. They stand before the family court judge and state a terrifying, incontrovertible fact. Yasmin and Hassan were never civilly married. Therefore, the family court has absolutely zero jurisdiction over their lives. The judge is constitutionally bound to agree. In a single stroke of the gavel, your entire identity as a wife is legally erased. The secular court looks at Yasmin not as a spouse entitled to equitable distribution, but as a legal stranger. You are classified as a mere roommate who happened to live in Hassan's house. Because Hassan's name is the only one on the mortgage, the property deed, and the investment accounts, he retains 100% of the wealth. You have no right to alimony because spousal support is a statutory right reserved exclusively for civilly married individuals. You are left entirely destitute, facing immediate eviction from the home you raised your children in, with absolutely no recourse in the family court system. But historical trends and current sociological data reveal a much darker layer to this phenomenon. This loophole is not just being used to avoid taxes. It is being actively weaponized to facilitate clandestine polygamy within the borders of the United States. In all 50 states, bigamy, the act of being civilly married to 2 people at the same time, is a strict criminal offense. To bypass this felony charge, bad actors engage in a highly calculated strategy of sequential, unregistered religious marriages. During the brutal discovery phase of Yasmin's attempt to sue Hassan in general civil court, a horrifying reality comes to light. Hassan is already civilly married to another woman in a different state. He never filed civil paperwork with Yasmin because doing so would have triggered a felony bigamy charge. Yasmin was unknowingly brought into a shadow marriage. She is a secret second religious wife. The first wife possesses the absolute, ironclad protection of the state, including inheritance rights, next of kin status for medical emergencies, and the full power of the family court in the event of a divorce. Yasmin, the unregistered wife, possesses absolutely nothing. This creates a terrifying asymmetry of power. The husband extracts all the cultural, physical, and social benefits of a recognized religious marriage without assuming a single ounce of the civil financial liabilities or state-mandated obligations of a legal husband. It is a perfectly engineered legal trap for exploitation. When Yasmin attempts to seek justice in the general civil court by suing for unjust enrichment or breach of contract, she faces an astronomical burden of proof. She must essentially prove that her relationship was a business partnership that defrauded her, a legal argument that costs tens of thousands of dollars to litigate and frequently fails. Furthermore, the only contract she has is her religious nikah, which, as we established, secular courts will aggressively refuse to enforce under the First Amendment if it is drafted with theological terminology. This systemic exploitation is forcing a massive, highly contentious reckoning within American Muslim leadership in 2026. We are witnessing the rapid expansion of a strict policy among progressive scholars and institutional mosques that mandates they will categorically refuse to perform a religious nikah unless the couple physically presents a valid, state-issued civil marriage license first. This institutional safeguard is designed to entirely eliminate the creation of these legally invisible, vulnerable spouses. However, rogue independent officiants still exist, operating entirely outside the oversight of established Islamic centers, willing to perform unregistered ceremonies for a fee or due to a radical ideological belief that secular American law is entirely irrelevant to their religious lives. The psychological devastation inflicted upon these women is profound. They are deeply stigmatized by their community as divorced women, carrying all the cultural shame associated with a failed marriage, while simultaneously being denied every single legal protection the secular state offers to divorced individuals. They are trapped in a space where both the religious and the secular systems have fundamentally failed to protect them. The children of these unregistered unions are caught in a vicious crossfire, their custody and financial support entirely dependent on brutal, high-friction paternity lawsuits rather than streamlined family court procedures. But what happens when this exact dynamic of legal invisibility and systemic exploitation is exported globally? What occurs when a United States citizen utilizes the extraordinarily complex, deeply intimidating web of federal immigration law, specifically the K-1 fiancé visa process, to bring a vulnerable spouse into this country, only to weaponize their immigration status alongside a religious marriage contract? We must now completely shift our focus to the international stage to examine one of the most terrifying, high-stakes legal nightmares in modern family law: the intentional entrapment of immigrant spouses who find themselves isolated in a foreign country, held hostage by the very person who sponsored their visa, and completely paralyzed by a dual legal system they do not understand. To comprehend the sheer magnitude of this hidden crisis, we must first completely separate the theological concept of marriage from the secular, administrative reality of the American state. In the United States, a marriage is fundamentally a civil contract authorized by a state government through the issuance of a marriage license. Religious officiants such as imams, priests, or rabbis act as dual agents. They perform the spiritual ceremony for the community, but they also act as temporary agents of the state by signing that civil license and filing it with the county clerk. However, a massive and deeply destructive loophole exists. If a couple undergoes a massive, culturally elaborate Islamic marriage ceremony, complete with a nikah contract, hundreds of guests, and total communal recognition, but they intentionally or negligently fail to file a civil marriage license with the state, they are completely invisible to the American legal system. They exist in a terrifying legal vacuum. Imagine if you are a woman named Yasmin living in Columbus, Ohio, right now in the year 2026. You are introduced to Dr. Hassan, a highly respected, affluent member of the local community. After a brief courtship, he proposes. He insists on having a beautiful religious nikah ceremony immediately to ensure your relationship is spiritually pure and culturally validated before God and your families. However, he tells you that for complicated tax purposes, asset protection regarding his medical practice, or perhaps a pending real estate transaction, you should wait a year or two before filing the actual civil paperwork at the courthouse. Trusting his status and surrounded by the overwhelming social proof of a massive wedding banquet, you agree. You move into his sprawling home. Over the next 6 years, you sacrifice your own career to raise 3 children, manage the household, and support his professional ascent. In the eyes of your community, your family, and your faith, you are unequivocally a devoted wife. Then the relationship catastrophically collapses. You discover a pattern of profound financial abuse and infidelity. Desperate to protect yourself and your children, you hire a civil family law attorney to file for a standard divorce, seeking child support, alimony, and your equitable share of the massive marital estate you helped build over the last 6 years. The attorney takes your retainer, files the petition in the Ohio Family Court, and awaits the response. The legal retaliation from Hassan is swift, brutal, and entirely legal. His corporate attorneys do not argue about asset division or alimony. They file a devastating motion to dismiss your entire case based on an absolute lack of legal standing. They stand before the family court judge and state a terrifying, incontrovertible fact. Yasmin and Hassan were never civilly married. Therefore, the family court has absolutely zero jurisdiction over their lives. The judge is constitutionally bound to agree. In a single stroke of the gavel, your entire identity as a wife is legally erased. The secular court looks at Yasmin not as a spouse entitled to equitable distribution, but as a legal stranger. You are classified as a mere roommate who happened to live in Hassan's house. Because Hassan's name is the only one on the mortgage, the property deed, and the investment accounts, he retains 100% of the wealth. You have no right to alimony because spousal support is a statutory right reserved exclusively for civilly married individuals. You are left entirely destitute, facing immediate eviction from the home you raised your children in, with absolutely no recourse in the family court system. But historical trends and current sociological data reveal a much darker layer to this phenomenon. This loophole is not just being used to avoid taxes. It is being actively weaponized to facilitate clandestine polygamy within the borders of the United States. In all 50 states, bigamy, the act of being civilly married to two people at the same time, is a strict criminal offense. To bypass this felony charge, bad actors engage in a highly calculated strategy of sequential, unregistered religious marriages. During the brutal discovery phase of Yasmin's attempt to sue Hassan in general civil court, a horrifying reality comes to light. Hassan is already civilly married to another woman in a different state. He never filed civil paperwork with Yasmin because doing so would have triggered a felony bigamy charge. Yasmin was unknowingly brought into a shadow marriage. She is a secret second religious wife. The first wife possesses the absolute, ironclad protection of the state, including inheritance rights, next of kin status for medical emergencies, and the full power of the family court in the event of a divorce. Yasmin, the unregistered wife, possesses absolutely nothing. This creates a terrifying asymmetry of power. The husband extracts all the cultural, physical, and social benefits of a recognized religious marriage without assuming a single ounce of the civil financial liabilities or state-mandated obligations of a legal husband. It is a perfectly engineered legal trap for exploitation. When Yasmin attempts to seek justice in the general civil court by suing for unjust enrichment or breach of contract, she faces an astronomical burden of proof. She must essentially prove that her relationship was a business partnership that defrauded her, a legal argument that costs tens of thousands of dollars to litigate and frequently fails. Furthermore, the only contract she has is her religious nikah, which, as we established, secular courts will aggressively refuse to enforce under the First Amendment if it is drafted with theological terminology. This systemic exploitation is forcing a massive, highly contentious reckoning within American Muslim leadership in 2026. We are witnessing the rapid expansion of a strict policy among progressive scholars and institutional mosques that mandates they will categorically refuse to perform a religious nikah unless the couple physically presents a valid, state-issued civil marriage license first. This institutional safeguard is designed to entirely eliminate the creation of these legally invisible, vulnerable spouses. However, rogue independent officiants still exist, operating entirely outside the oversight of established Islamic centers, willing to perform unregistered ceremonies for a fee or due to a radical ideological belief that secular American law is entirely irrelevant to their religious lives. The psychological devastation inflicted upon these women is profound. They are deeply stigmatized by their community as divorced women, carrying all the cultural shame associated with a failed marriage, while simultaneously being denied every single legal protection the secular state offers to divorced individuals. They are trapped in a space where both the religious and the secular systems have fundamentally failed to protect them. The children of these unregistered unions are caught in a vicious crossfire, their custody and financial support entirely dependent on brutal, high-friction paternity lawsuits rather than streamlined family court procedures. But what happens when this exact dynamic of legal invisibility and systemic exploitation is exported globally? What occurs when a United States citizen utilizes the extraordinarily complex, deeply intimidating web of federal immigration law, specifically the K-1 fiancé visa process, to bring a vulnerable spouse into this country, only to weaponize their immigration status alongside a religious marriage contract? We must now completely shift our focus to the international stage to examine one of the most terrifying, high-stakes legal nightmares in modern family law: the intentional entrapment of immigrant spouses who find themselves isolated in a foreign country, held hostage by the very person who sponsored their visa, and completely paralyzed by a dual legal system they do not understand. To fully grasp this specific nightmare, we must examine the intersection of federal immigration law, state family court, and Islamic jurisprudence. When a United States citizen decides to sponsor a spouse from overseas, they trigger one of the most rigorous, legally binding, and potentially dangerous administrative processes in the entire American judicial system. In the year 2026, navigating the federal immigration apparatus is notoriously backlogged, heavily scrutinized, and incredibly expensive. The American sponsor holds an absolute monopoly on the legal documentation required to secure the immigrant spouse's right to exist within the borders of the United States. This creates an immediate, staggering imbalance of power that bad actors aggressively exploit to establish total coercive control over their newly arrived partner. The immigrant spouse is stripped of their native support networks, isolated in a new cultural landscape, and forced to rely entirely on the person who holds the literal keys to their legal survival. Imagine if you are a woman named Amina, an educated professional living in Cairo, Egypt. You meet a man named Adam, a financially successful American citizen residing in Houston, Texas. After a period of international courtship, Adam travels to Egypt to formalize the relationship. You engage in a traditional, culturally significant religious nikah ceremony surrounded by your extended family. However, this marriage is intentionally not registered with the Egyptian civil authorities because Adam insists on utilizing the K-1 fiancé visa process to bring you to the United States. In the eyes of the United States Citizenship and Immigration Services, you are legally single. You arrive in Texas in the current year 2026, completely unaware of the legal trap that has just been set. Federal immigration law mandates that you must execute a civil marriage license within exactly 90 days of your arrival. Adam waits until the 89th day. He then presents you with a highly restrictive civil prenuptial agreement, drafted entirely in complex English legal jargon, and issues a devastating ultimatum. You either sign the civil contract waiving all of your equitable rights to his massive estate, or he refuses to sign the civil marriage license, which automatically triggers your immediate deportation back to Egypt. Under extreme duress, terrified of the profound cultural shame associated with returning home as a rejected bride, you sign the document. You are now civilly married under Texas law, but the religious contract you signed back in Egypt, the one containing your mandatory mahr and your deferred financial safety net, is completely superseded and nullified by the civil paperwork you just signed. Fast forward 3 years, and the marriage has devolved into a nightmare of severe financial abuse and psychological torment. Adam uses your precarious, conditional permanent resident status as a weapon of absolute compliance. He reminds you daily that your green card is heavily conditional, and he possesses the unilateral power to refuse to sign the joint petition required to remove those conditions. If you dare to seek a civil divorce to escape the abuse, he explicitly threatens to contact federal immigration authorities, falsely claim your marriage was fraudulent from the inception, and have you deported. If you bypass the civil courts and approach the local Houston religious tribunal seeking a Khula, an Islamic divorce, he threatens to withdraw all financial support, leaving you destitute and homeless in a country where you have zero credit history, no independent income, and a looming expiration date on your legal residency. The legal reality of this specific dynamic is statistically terrifying. The immigrant spouse is trapped in a multi-jurisdictional black hole. The state family court judge presiding over a civil divorce cannot directly intervene in federal immigration matters or stop a deportation. The federal immigration agents adjudicating your residency status do not care at all about your religious marriage contract or the theological nuances of your spiritual divorce. Furthermore, the local religious tribunal mediating your Islamic divorce has absolutely zero statutory authority to compel your abusive husband to sign your federal immigration paperwork. You are completely paralyzed by a fragmented system where no single judge, arbitrator, or agent has the total authority to save you. However, historical trends in federal legislation provide a highly specific, aggressively litigated escape mechanism. Under the Violence Against Women Act, an immigrant spouse enduring extreme cruelty or battery can completely bypass their American sponsor and file a self-petition for their permanent green card. But accessing this federal protection requires a monumental burden of empirical proof. Amina must essentially act as her own private investigator, compiling a massive dossier of police reports, psychological evaluations, and sworn affidavits demonstrating a pervasive pattern of coercive control. She must litigate a highly complex federal immigration case while simultaneously fighting a brutal civil divorce in state court and enduring a grueling religious divorce mediation in her community center. This creates a disastrous friction point when analyzing the role of private religious arbitration panels in these immigration scenarios. If Adam legally forces Amina into a closed-door religious mediation to settle their divorce, and Amina discloses the extreme cruelty she suffered to the religious scholars in an attempt to justify her request for a Khula, the panel is absolutely not bound to preserve that testimony for the federal government. In fact, Adam's civil defense attorneys might maliciously weaponize the fact that Amina participated in the religious mediation at all. They will present arguments to the secular family court, and the immigration judge suggesting that a truly terrified victim of extreme cruelty would never willingly sit in a small room with their abuser to negotiate a theological settlement. This places the immigrant spouse in an impossible, terrifying paradox. To save their standing in their faith community and secure their spiritual freedom, they must participate in the religious process, but by simply participating in that religious process, they severely jeopardize the credibility of their federal immigration case and their fundamental legal right to remain safely in the United States. Furthermore, we must examine the financial devastation associated with the federal affidavit of support, known as Form I-864. When Adam sponsored Amina, he signed a binding contract with the United States government, guaranteeing he would maintain her at 125% of the federal poverty guidelines. If Adam civilly divorces Amina, he is still federally mandated to provide that financial support. But enforcing this federal contract in a state family court is an absolute logistical nightmare. Most state family court judges in 2026 lack the specific jurisdictional experience to seamlessly enforce federal immigration support affidavits during standard alimony calculations. Adam can simply refuse to pay the federal support, forcing Amina, who is already bankrupt from fighting the civil divorce and the immigration battle, to file a completely separate, astronomically expensive breach of contract lawsuit in United States District Court. She is fighting a four-front war of attrition. This staggering level of institutional friction, the weaponization of civil procedure, and the sheer financial devastation of these multifaceted divorces do not occur in a vacuum. They produce massive, unavoidable generational collateral damage. When parents spend 5 to 10 years locked in this brutal, cross-jurisdictional warfare, the children become the silent casualties, absorbing every single ounce of the legal, financial, and spiritual trauma radiating from the collapse of the family unit. But how exactly is the new generation of American Muslims, those born and raised entirely within the borders of the United States, responding to this legacy of systemic institutional failure? What potential outcomes arise when these children grow up, enter the marriage market themselves, and radically rewrite the entire sociological script regarding gender roles, mental health, and the stigma of divorce, creating a cultural revolution that is actively terrifying traditional community elders? To understand this profound cultural revolution, we must first deeply analyze the demographic data and the psychological profile of the modern American Muslim. We are no longer talking about an immigrant population navigating the initial disorienting shock of assimilation. In the year 2026, the vast majority of individuals entering the marriage market are second and third generation citizens. They were born in local hospitals, educated in American universities, deeply integrated into the American corporate workforce, and heavily influenced by Western concepts of individualism, therapeutic language, and psychological well-being. This demographic reality creates an immediate, explosive ideological clash with the generation that preceded them. Traditional community elders generally operate on a strict collectivistic paradigm. Within this framework, marriage is not merely a union of two individuals seeking personal happiness. It is a vital, structural alliance between families, designed to ensure social stability and communal continuity. Consequently, divorce is viewed as a catastrophic communal failure that brings profound social shame. Historical trends within these traditional structures show that elders prioritize the survival of the family unit above almost all else, frequently advising vulnerable spouses to endure extreme emotional neglect, financial control, or severe domestic dysfunction, simply to avoid the stigma of a broken home. But the new generation of American Muslims is aggressively and unapologetically rejecting this paradigm. They view marriage as an equal partnership predicated on mutual emotional fulfillment, equitable labor, and psychological safety. Furthermore, they view divorce not as an ultimate moral failure, but as a painful, highly necessary mechanism for self-preservation and mental health. Imagine if you are a 28-year-old software engineer named Bilal, living in Seattle in 2026. You are engaged to Layla, a highly successful corporate attorney. When you approach your local traditional imam to discuss your upcoming marriage, the imam hands you a standard, generalized religious contract and offers a brief, standardized lecture on obedience, patience, and traditional gender roles. 15 years ago, couples would simply nod respectfully, sign the paper, and leave the office. Today, Bilal and Layla refuse the document entirely. Instead, they demand a rigorous 6-month premarital counseling program facilitated not by an elder, but by a licensed, state board-certified psychotherapist who also possesses a background in Islamic theology. Bilal and Layla are meticulously discussing emotional triggers, trauma responses, financial independence, and the equitable division of domestic labor long before they ever discuss the theological mechanics of the Nikah ceremony. This profound psychological shift directly translates into an aggressive, highly sophisticated legal strategy. The new generation has witnessed firsthand the financial ruin of their mothers, aunts, and community members. They have seen the devastating potential outcomes of relying solely on verbal promises, cultural goodwill, or informal community mediation when a marriage collapses. Therefore, they are entering the institution of marriage with an unprecedented level of legal cynicism and fierce self-advocacy. They are actively weaponizing secular American family law not to attack their faith, to legally protect themselves from the patriarchal loopholes that have historically been exploited within their own communities. Let us examine the actual contractual clauses being drafted by couples like Bilal and Layla today. They are not merely writing down a standard deferred financial gift. They are constructing highly complex, legally binding civil prenuptial agreements that explicitly define the financial penalties for emotional abuse, mandate the joint custody of all future acquired assets, and completely, legally bypass local traditional arbitration councils. They are legally stipulating that if a divorce occurs, the process will be handled entirely by certified secular mediators and civil judges, explicitly stripping the traditional community elders of any jurisdictional power over their personal or financial lives. This structural bypass is actively terrifying traditional community leaders, and for a highly specific institutional reason. For decades, the local mosque and the Council of Elders served as the undisputed Supreme Court of the community. They held the ultimate, unchecked authority to mediate disputes, grant religious divorces, and dictate the moral and social standing of an individual. But the new generation is simply walking away from this table. When a community loses its monopoly on dispute resolution, it fundamentally loses its power to enforce cultural compliance. The elders view this shift not just as a rejection of their personal authority, but as a dangerous erosion of Islamic identity, fearing that this hyper-individualistic approach will lead to skyrocketing divorce rates and the ultimate secularization of the Muslim family structure in America. Furthermore, the integration of clinical psychology into the religious divorce space is causing massive, systemic institutional friction. Historical trends within many immigrant communities often stigmatize mental illness, framing severe depression, anxiety, or emotional volatility as a lack of faith or a spiritual deficiency. If a woman requested a religious divorce due to her husband's covert narcissism or emotional manipulation, traditional mediators often dismiss these claims entirely, demanding empirical proof of physical harm before granting a khula. Today, young American Muslims are dragging the diagnostic and statistical manual of mental disorders directly into the religious mediation rooms. They are utilizing legal and clinical terms like coercive control, gaslighting, and generational trauma as legitimate, religiously valid grounds for immediate marital dissolution. We can look at the recent legislative changes in states like California, which officially codified coercive control as a form of domestic violence in family court. The new generation is taking these secular civil rulings of coercive control and presenting them to progressive religious scholars to instantly justify their spiritual divorce, completely bypassing the abusive husband's refusal to grant a release. This leaves the traditional older mediators entirely unequipped and paralyzed. How does an elderly religious scholar, trained primarily in classical centuries-old jurisprudence, adjudicate a divorce where the primary complaint involves sophisticated psychological abuse tactics defined by modern American law? The blunt reality is that they cannot. Because the traditional infrastructure cannot handle these complex intersections of law and psychology, the youth are abandoning them, opting instead for a rapidly expanding wave of hybrid professionals. These are individuals who hold rigorous academic degrees in Islamic theology, while simultaneously maintaining state licenses in clinical social work or secular law. These hybrid professionals are fundamentally restructuring the entire divorce process from the inside out, ensuring that mental health evaluations, strict secular legal compliance, and psychological safety are aggressively prioritized above the mere preservation of a toxic, failing marriage. This generational rebellion is forcing a massive, unprecedented reckoning within the American Muslim infrastructure. The legacy institutions are bleeding relevance, the traditional contracts are systematically failing in secular courts, and the youth are completely rewriting the sociological rules of engagement. The entire system is buckling under the immense weight of this cultural evolution. So what happens when this unstoppable force of modernization finally shatters the immovable object of theological tradition? We must now turn our attention to the final, most critical phase of this deep dive masterclass to examine the definitive future of Islamic family law in the United States. Analyzing the groundbreaking Supreme Court cases on the horizon, the radical new institutional models being built from the ashes of the old system, and the ultimate, high-stakes legal synthesis that will determine if American Muslims can successfully navigate the most complex constitutional tightrope in modern history. The ashes of the old system, and the ultimate, high-stakes legal synthesis that will determine if American Muslims can successfully navigate the most complex constitutional tightrope in modern history. To comprehend the magnitude of this impending legal synthesis, we must examine the appellate battlegrounds of 2026, where state Supreme Courts are actively dismantling and reconstructing the boundaries of the First Amendment in real time. We are no longer dealing with low-level trial court confusion. We are witnessing highly coordinated, multi-million-dollar litigation strategies designed to force the American judicial system to establish a permanent, unified precedent regarding Islamic family law. Consider a landmark appellate scenario currently mirroring cases in jurisdictions like Texas and New York. Imagine a case where a modernized, entirely secularized Islamic prenuptial agreement, drafted by elite corporate attorneys to protect a massive deferred marital gift, is challenged by a wealthy spouse who claims the contract, despite its secular language, is a disguised religious edict and therefore unenforceable by a secular judge. When this case reaches the state Supreme Court, the justices face a profound constitutional dilemma. If they strike the contract down simply because the original intent of the parties was religiously motivated, they risk establishing a terrifying precedent that invalidates the private contractual rights of millions of religious citizens. They would be declaring that people of faith possess fewer rights to freely contract their financial futures than secular citizens. Conversely, if they uphold the contract, they must provide a bulletproof, standardized legal test for lower courts to follow, ensuring that judges can enforce these agreements without ever accidentally interpreting theology. The potential outcomes of these high-level appellate decisions will instantly rewrite the operational procedures for every family law practitioner in the United States. We are seeing appellate courts leaning toward a strict, four corners contractual synthesis. This means that as long as the document utilizes standard American commercial terminology, includes robust severability clauses and demonstrates clear, informed consent from both parties, the secular court will enforce the financial stipulations with absolute, ruthless efficiency, regardless of the underlying religious motivation. This judicial strictness is actively birthing a radical new institutional model that is completely replacing the traditional, informal community tribunals of the past. Rising from the ashes of the old system is the concept of the unified, dual-licensed arbitration board. These are highly structured, deeply funded national organizations operating out of major metropolitan hubs in 2026. If you walk into one of these new arbitration centers, you will not find a lone religious elder mediating a dispute in a mosque basement. You will find a panel consisting of 3 specialized professionals: a state board-certified clinical psychologist, a classically trained Islamic scholar who also holds a Juris Doctor from an American law school, and a former secular state family court judge acting as the neutral procedural oversight. These new boards operate under a staggering level of bureaucratic and legal rigor. Before a couple can even enter mediation, they must sign a binding arbitration agreement that explicitly subjects the panel's final ruling to standard state appellate review for fundamental fairness and constitutional compliance. This completely eliminates the terrifying black hole of unappealable religious rulings that previously trapped so many vulnerable spouses. Furthermore, these new institutions absolutely refuse to adjudicate matters of child custody or child support, strictly deferring those issues to the secular state courts to ensure total compliance with the legal doctrine of the best interests of the child. By intentionally limiting their own power and willingly submitting to secular oversight, these new arbitration models are achieving a brilliant, high-stakes legal synthesis. They are retaining their theological integrity while actively integrating into the American legal framework as a highly respected, legally untouchable form of alternative dispute resolution. Simultaneously, we are tracking a massive sociological evolution in how the American Muslim community approaches the very inception of marriage. The historical trends of rushing into a religious ceremony, based purely on cultural expectations, are collapsing. In 2026, the premarital landscape is dominated by mandatory, highly rigorous educational curriculums. Progressive Islamic centers across the United States are completely refusing to perform the nikah ceremony unless the couple successfully completes a certified, multi-week boot camp that fuses Western financial planning, constitutional law education, and psychological assessment. Couples are actively taught how to identify the subtle red flags of coercive control, how the equitable distribution laws of their specific state will override their cultural assumptions, and exactly why they must retain independent civil counsel before signing any marital document. This proactive, defensively engineered approach to marriage is creating a generation of profoundly legally literate citizens. They are not waiting for the courts to save them. They are utilizing sophisticated, aggressively secular legal mechanisms to build a fortress around their religious identities and their financial futures. They are demanding transparency, psychological safety, and absolute legal parity. This is the ultimate synthesis. It is the realization that true religious freedom in the United States does not mean escaping the secular legal system, but rather mastering the secular legal system so completely that it can be used to perfectly enforce and protect one's religious values without ever violating the Constitution. The transition from the vulnerable, newly arrived immigrant generation to the legally empowered, institutionally sophisticated reality of 2026 represents one of the most remarkable sociological adaptations in modern American history. The community has endured decades of fractured legal outcomes, profound systemic exploitation, and agonizing cultural civil wars over gender dynamics and institutional authority. Yet, through rigorous academic study, relentless appellate litigation, and a complete refusal to accept the status quo, a new stabilized landscape is rapidly emerging. The American Muslim divorce is no longer a chaotic collision of incompatible worlds. It is becoming a highly predictable, fiercely negotiated process governed by a new class of hybrid legal professionals and dual-licensed institutions. Throughout this exhaustive masterclass, we have completely deconstructed the mechanics of the MAR, the weaponization of the civil and religious courts, the devastating loopholes of unregistered marriages, the terrifying intersection of federal immigration law, and the profound generational shift completely rewriting the rules of engagement. You now possess a master-level, academically rigorous understanding of how Islamic family law actually functions within the rigid confines of the United States legal apparatus. You understand the profound systemic failures of the past, the aggressive legal hacking of the present, and the stabilized dual-licensed institutional models dictating the future. But just when the domestic legal landscape finally appears to reach a stable, predictable equilibrium, a terrifying new mechanism of financial evasion is quietly emerging among the ultra-wealthy. What happens when a legally sophisticated spouse entirely bypasses both the American secular courts and the new unified religious arbitration boards by funneling the entirety of their marital estate into a complex, religiously compliant offshore asset protection trust located in a sovereign jurisdiction that refuses to recognize American subpoenas? In our highly requested, completely unlisted bonus masterclass, we are going to tear open the dark, entirely unregulated world of international Islamic trust law, and expose the exact strategies high net worth individuals are using right now to legally vanish millions of dollars overnight.